Hi everyone, Joe Gentili from Saraf Gentili LLP. So traditionally, one of the hardest cases to bring in federal court in immigration law is to fight the denial of an immigration benefit that comes from a U.S. consulate. There's a doctrine known as consular non-reviewability that basically says that with very few exceptions, consular decisions are not reviewable by courts. Whatever the consulate decides is final, which can be very frustrating because consulates, like every other agency, makes mistakes. And there's really very little way to have a check on them when they do make a mistake. That changed a little last week. There was a decision in the Ninth Circuit Court of Appeals, which is the court in the U.S. federal system that sits just below the U.S. Supreme Court, and it covers most of the western part of the United States. And there was a case called Munoz versus Department of State. And in that case, the doctrine of consular non-reviewability got pierced. It was dented. And this is a big deal because it gives a lot of people hope where there previously was none. And what that case said is that if the consulate does not give you a rationale as to why they're denying your case, and that denial impacts the constitutional rights of U.S. citizens. Let's say you have a U.S. citizen spouse, maybe or close family member, maybe even an employer, and that decision negatively impacts them. And if there's no rationale, there's no way to contest it, then there's no due process. And if that's the case, then the Court of Appeals said that consular non-reviewability doesn't apply, and the consular decisions can be reviewed just like a decision at USCIS could be reviewed. That's a big deal, particularly for people that can bring cases in the western part of the U.S. There's very good precedent now that says that there's situations where you can challenge a decision of a consulate. This is something very new. And also, if you can't bring your case in the western part of the U.S., it's still good news, because now if you're going to bring your case in New York or even Washington, D.C., it gives you some ability to point to a well-respected court that has a well-rationed decision that says, look, in this situation, another court held that consular non-reviewability does not apply, so therefore, judge, you can review this decision. And that may be persuasive. Perhaps that the court where you are outside of the Ninth Circuit could adopt that as well. So this is some good news for people that are struggling because they have a denial from a consulate. It's not a silver bullet. It's not going to work in every situation, but it does give some hope and something to argue where previously there really was very little. I am going to include a link to the decision in the description of the video if you want to read it for yourself. And if you have any questions, please feel to reach out. Thank you.